So I will quickly go to the second policy, and this is on client funds handling policy. Again, a rather obvious policy. We practice it every day, but without any written, document. But essentially, if your firm or your practice has this policy, then of course you are able to know that it will provide for proper receipting, it will provide for management and disbursement of client funds. It again enables the firm to actually have a commitment to comply with all the applicable laws in terms of provisions on accounting under the LSK or Advocates Act. Now, what are the key features of the client funds handling policy? Once you have this particular policy, you are able to tell you are able to tell whether or not, for instance, you can invest a client's deposit or client's money in an interest earning account. You might know that some agreements would allow a client would allow you to fix the money in an interest earning account. But of course, again, there has to be particularity in terms of how is the interest to be utilized. Of course, this policy again touches on something very fundamental. It touches on retainers. How are the retainers to work? How are the deposits to be accounted for? It further goes on to talk about disbursement. What is it? What forms are part of acceptable disbursements? And of course, there's a whole list of the things that are cost related, case related expenses, which are the expenses that can only be reimbursed. Of course, it goes on to talk about the other aspects of aspects of the items that you cannot utilize in terms of in terms of money from the client account. So that will mark the end of that particular policy.